Young Thug's attorney moves to free rapper, remove judge from recusal decision. Young Thug attorney Brian Steele calling for Judge Rachel Krause to remove herself from Euro Glanville recusal decision. The attorney for acclaimed rapper Young Thug, who is at the center of one of the nation's most watched criminal trials, is calling for the judge who will decide whether to recuse the judge overseeing the trial to step away from making that decision and for his client to be released from custody. In an over 200-page motion filed late Tuesday, Brian Steele called for Judge Rachel Krause to recuse herself from deciding if Chief Superior Court Judge Euro Glanville should be removed from overseeing the YSL trial.
As you come on to the page, kindly hit the like bell and subscribe to the channel if you haven't done so as yet. And don't forget to put on the notification bell so you can be notified when I drop the next video. Thank you.
This motion also timely moves to recuse the Honorable Judge Krause based upon the fact that she sits on the Fulton County Superior Court bench with Judge Glanville and that in April 2024, Judge Glanville contributed $2,000 to the Honorable Judge Krause's re-election campaign, the motion states. Steele's motion calls for his rapper client, whose real name is Jeffrey Williams, to be released from jail and cleared of all charges based upon prosecutorial and judicial misconduct. The rapper's attorney is also calling for Adrian Love and Simone Hilton, two of the case's top prosecutors, to be disqualified from the case. Fulton County DA Fonnie Willis' office had until 5 p.m. Monday to respond to motions from defense attorneys to recuse Glanville, but now have until 5 p.m. on Wednesday, July 10th. Recently, Glanville put the trial on an indefinite hold until the recusal decision is made. Steele filed the motion for Glanville to recuse himself. At the center of the trial's latest delay is a June 10, 2024, ex-parte meeting held between Glanville, two Fulton County prosecutors, star prosecution witness Kenneth Copeland aka Woody or Lil Woody, and his stand-in attorney, Kayla Bumpus. The legal term ex-parte, translated from Latin as out of the party, refers to a decision made by a judge without requiring all parties in a dispute to be present. Glanville released that meeting's timeline and transcript, a meeting that later that day resulted in Steele being held in contempt of court. Steele and Young Thug's other attorney, Keith Adams, have repeatedly moved for a mistrial, as have attorneys for some of the other defendants in the trial. Glanville had been denying all of the repeated motions, as well as motions from Steele and other attorneys to recuse himself from the trial until recently. The trial's jury selection lasted longer than any other in Georgia history, and actual witness testimony itself will likely surpass state records. Both records were set by the Atlanta Public Schools teacher scandal and trial of 2014-15. Prosecutors are attempting to show YSL, or Young Slime Life, is a criminal street gang responsible for numerous offenses. Defense attorneys say YSL is not a gang but simply the name of a record label, Young Stoner Life. Young Thug is facing 8 criminal counts under a federal law that was originally enacted to fight organized crime. Georgia is one of 33 states with its own RICO law, but in the Peach State, the alleged criminal enterprises do not have to have existed as long as the federal law.
Thank you for having me.
Okay, so, what we've been following very closely is what I think so much of our audience has been following closely, the latest in the YSL trial, which many people say is kind of now in limbo. A lot of other adjectives being used for what's been going on in this trial. But just kind of getting our viewers up to speed a little bit here, because it is hard to keep track of. So that's Judge Euro Glanville. And, we reported to you, and that's Jeffrey Williams with his attorney, Brian Steele. And we reported to our viewers throughout, as these new developments were happening, that Mr. Steele and his team basically filed a motion. They want Judge Euro Glanville to recuse himself from the case for a variety of reasons. That's a whole tangent we're going to get into. But now the newest thing is they now want the judge who's deciding whether Mr. Glanville should get off the case. They want that judge, her name is Rachel Krause, to get off the case too, and they want 2 prosecutors to get off the case. So this is like you told me, drama upon drama upon drama.
Yes.
This is, I know you're a very experienced trial attorney. How unusual is this?
This is something that you don't see every day, if ever. We are watching a historic thing happen, especially here in Fulton County. We've never seen anything like this. just reading parts of the 200-page motion that Mr. Steele filed, it just goes into detail of just how unprecedented this is. So I think that, you know, people are going to study this for years to come and say, wow, we've never seen anything like this.
Yeah, so we were talking about years to come, but I mean, I feel like saying it could be years to come before we see the end of this trial at the rate that we're going, because this has already been a historically long trial. The jury selection took about a year, right?
That's true.
Am I wrong on that? And
you're going down the right path.
And now, you know, now the trial is delayed after delay, and the whole thing's been put on hold because there has to be this determination made about whether Mr. Glanville, or I should say the Honorable Judge Earl Glanville, his honor, whether he should be removed from the case, whether the judge overseeing that should be removed the case, and whether the, you know, two prosecutors should be removed from the case. So the whole thing is like delay again.
That's correct. And I think it's going to cast a kind of a dark cloud over the district attorney's office, because we're looking at something that, again, is unprecedented. She's already had to fight the firestorm of dealing with the Donald Trump case, which we're all very well aware of. And now she's looking at what has been, for the past year and some change, a chance to just blow it up, have a mistrial declared, and have to determine whether or not she wants to start again.
Okay, so, you know, the headline here, and I actually wrote that headline, Young Thug's attorney moves to free rapper, and that's part of it. That's part of what we're talking about as well, moves to the judge in charge of the recusal decision. So in terms of freeing Jeffrey Williams, is the argument for that based on delay? Or what is the argument for freeing Mr. Williams?
Well, the limited amount of dealings I've had with Attorney Steele, he's more of a very substantive attorney. He looks at what is in front of him and he makes the best decision based on those facts. And the facts that have been given to him point to there being some constitutional protections being violated for Mr. Williams. Now, people may have their ideas about the innocence or guilt of a defendant at any given time, but in this country, we have these constitutional protections that we have to fight for. And by calling out the fact that a lot of these are being violated, in Mr. Steele's eyes, it just brings up this whole question of whether or not he'll be able to get his client free.
Yeah, definitely. Okay, so part of the argument for removing, like I said, Mr. Steele, the attorney for Young Thug, he's called for Judge Rachel Krause to recuse herself from deciding if Judge Glanville should stay on the case. And what he's pointing to is the fact that Mr. Glanville, the Honorable Judge Glanville, contributed $2,000 to the Honorable Judge Krause's re-election campaign, according to this motion, and did that in April of this year, so pretty recently. Is that typically a reason to remove a judge from, overseeing what is typical? I mean, the recusal of another judge, which actually isn't really a typical thing either. So as I'm saying it out loud, I'm like, okay, this isn't typical.
Right. So I would go on to say that a lot of us attorneys, we do donate to each other's campaigns.
Okay.
Well, not each other, but, judges' campaigns, things of that nature. It's not atypical to have a judge donate to another's campaign. However, he is grasping upon this and saying, because you donated, therefore I'm expecting almost a quid pro quo by you saying that I am able to stay on this case.
Gotcha.
And in fact, he wants to keep any chance of there being any impropriety seen or even thought of by saying, okay, we need another judge to determine whether or not Judge Glanville should recuse himself.
Yeah. I'm not sure that I understand the arguments for removing the two prosecutors. So the defense wants to have two of the prosecutors, Adrian Love and Simone Hilton, their two top prosecutors, to be disqualified from the case. I'm not sure if I understand what the reasoning is for that.
So I've talked to various attorneys. Two attorneys that come into mind are Lamar Gardner and Julius Collins, and we have talked about this many times. We have determined that these two attorneys are almost inserting themselves into the case by engaging in this conduct that is alleged to have been improper. Now, if they have inserted themselves into the case, they are in fact material witnesses, because the allegation is that due to their actions, the witness, Mr. YSL Woody, they're determining that their actions actually influenced him to testify when he wasn't going to testify. So Mr. Steele's motion says that by them doing their improper, I guess, influence on Mr. Woody, then that leads us to determine that they are actual, in fact, witnesses, because their actions shouldn't have been done. And he wants to have a direct examination of whether or not they actually engaged in any improper actions to lead Mr. YSL Woody to testify.
So talking about this issue of Judge Glanville, whether he should recuse himself or not, I mean, that underlying issue, what do you think? Should he recuse himself? I mean, I remember that the defense asked him to recuse himself, and he said no, essentially. And so then there was a motion filed, and brought it up the flagpole, and so now you got this other judge deciding on this issue. Do you think that Judge Glanville should recuse himself?
So, having practiced, I believe anytime we have a defendant and it seems like things are a bit one-sided, of course we're going to ask for a recusal. But objectively speaking, there are a lot of issues that one could point at and say, yeah, we do need this judge to go ahead and recuse himself, if not for his own self-preservation, but to just make sure that we continue to have fair trials here in the state of Georgia.
So I want to ask you, I mean, do you think that this is really do you think that there is a very strong concern about the fairness of this judge, or do you really think this is basically misdirection, that the defense is trying to create a whole sideshow so you focus over there instead of on the accusations against the defendants?
I have seen some attorneys who do engage in sideshows. I've seen it very recently, but particularly with Mr. Steele, I don't think he's the type of attorney to engage in sideshows. He is one who is very well versed in the law. He mentors a lot of individuals, as evidenced by all the attorneys that showed up when he was held in contempt. He is someone who knows the law very well. So I think that this is more of Mr. Steele having a passion for the law and determining, hey, something is not right. I am screaming at the top of my lungs that it's not right. And now, with no other avenues to kind of pursue, I have to go to a higher court and see if we can get a recusal and have that affirmed by this higher court.
Okay, so, the first time around, I'm saying the first time around because potentially this jury selection could happen again, right?
Right.
First time around, it was really hard to select a jury, and part of the reason is because this is a really high-profile case. People knew about it, people had preconceived notions about it, and the object is to find an unbiased jury of peers, right?
Correct.
So now, that's going to be, multiplied exponentially, because this has been all over the media because the trial's now underway and the jury is supposed to, not pay attention to what's happening in the media, which, of course, many question whether that's actually happening. But this has gotten so much more media attention since the trial has begun, and there's all this controversy surrounding the judge, and then the judge deciding upon the judge, and all of that. So, if this does happen again, I just can't imagine how challenging it's going to be to seat a jury if there's a mistrial.
I think that there is going to be a lot of questions in that district attorney's office on whether or not they want to even go back and try it again, or if they are willing to come to the negotiating table and say, okay, here's what our plea offer is, and let's try to negotiate this so the taxpayers don't have to pay for another trial again that may take 3 to 5 years. We're on very well deep into year 2, and there's no end in sight. So again, there's going to be a lot of questions in that office on what is going to be our next move, other than trying try this case all over again.
And that's why I often do wonder if this was sort of manufactured as kind of a delay, a distraction, so that essentially we're in a situation where there potentially could be a mistrial, and this trial may have to start over again. And that would be favorable to the defense because, like you said, that kind of puts the prosecution, the state, in a situation where they look, we're already 2 years in. Do we want to go for another 3 years potentially?
True. I think the difference between manufactured outrage, quote unquote, and this is a lot of the manufactured issues that we've seen recently. They really had no basis in anything in law or anything in fact. There were some salacious allegations against the district attorney's office that did play a sideshow to the case that was at hand. However, there are no salacious allegations in this. This is pretty much fact, and the transcript proves it. And the law that goes along with this is very clear. Ex parte communications, you have to have all essential parties there. So I don't think that it would be a sideshow as much as it's an attorney who's very passionate about the law and how it should be interpreted, going for, everything to make sure that his client gets a fair trial.
Any final thoughts on this?
I wish the best to those jurors, and hang in there, guys.
Yeah, because it's been a long one, and looks like it's going to continue to be a long one, not wrapping up anytime soon, I would guess. Well, we so appreciate you being here with us, Jamara Edwards-Shipp. Thank you so much for your expertise and your analysis.
Thank you.
And for our viewers, just want to point you all to AtlantaNewsFirst.com.
As you leave the page, don't forget to hit the like bell and subscribe to the channel if you haven't done so as yet. Thank you for watching.